Washington state has some of the most detailed and tenant-protective lease termination laws in the country, and they've gotten even more restrictive in recent years. If you manage rental property in Washington, staying current on these laws isn't just recommended, it's essential to avoiding serious legal consequences. Washington's lease termination framework is found in the Residential Landlord-Tenant Act, RCW Chapter 59.18. along with the state's unlawful detainer statute in RCW Chapter 59.12. In 2021, the legislature passed significant reforms that fundamentally changed how landlords can terminate tenancies in Washington, so if you're operating based on rules you learned years ago, it's time to update. The biggest change: Washington is now effectively a just cause eviction state. Under RCW 59.18.650, landlords can only terminate a month-to-month tenancy or decline to renew a fixed-term lease for specific reasons enumerated in the statute. You can no longer simply give a tenant 20-day notice to vacate without cause. The recognized grounds for termination include non-payment of rent, material lease violations, waste or nuisance, owner move-in, substantial rehabilitation, demolition, conversion to non-residential use, and certain other specific circumstances outlined in the law. For non-payment of rent, Washington requires the landlord to provide a 14-day notice to pay or vacate. This is a significant change from the previous 3-day notice that was standard for decades. The 14-day window gives tenants substantially more time to come up with the rent, and the notice must include specific information about the amount owed and how the tenant can pay. If the tenant pays the full amount within the 14-day period, the notice is void and the tenancy continues. Washington also requires landlords to provide tenants with information about rental assistance programs when issuing a pay or vacate notice. This requirement was added during the pandemic-era reforms and has remained in effect. Failure to include this information can invalidate the notice. For lease violations other than non-payment, the process depends on the nature of the violation. For violations that can be corrected, like unauthorized occupants, pets, or parking issues, the landlord must issue a 10-day notice to comply or vacate. The tenant gets 10 days to fix the problem. If they comply, the tenancy continues. If they don't, the landlord can proceed with filing for eviction. For repeated violations of the same type within a 12-month period, Washington allows the landlord to issue a subsequent 10-day notice without an opportunity to cure after the third occurrence. This means the tenant gets chances to fix the problem the first 2 times, but by the third violation of the same provision, the landlord can proceed directly to eviction. For serious violations, including criminal activity, drug manufacturing or distribution on the premises, or conduct that poses an imminent threat to the physical safety of other residents, the landlord can issue a 3-day notice to vacate with no opportunity to cure. This is the fastest termination pathway in Washington and is reserved for the most serious situations. For waste or nuisance, meaning the tenant is substantially damaging the property or creating conditions that seriously interfere with other tenants' quiet enjoyment, the landlord can issue a 3-day notice to vacate. Owner move-in evictions are permitted but heavily regulated. The landlord must provide at least 90 days' notice. The landlord or an immediate family member must intend to occupy the unit as their primary residence for at least 12 consecutive months. And in some Washington cities, particularly Seattle, there are additional local requirements, including relocation assistance payments that can amount to several months' rent. Speaking of Seattle, the city has its own just cause eviction ordinance that predated the statewide reforms and in some ways provides even stronger protections than state law. Seattle landlords face additional restrictions, longer notice periods, and mandatory relocation assistance in certain termination scenarios. Tacoma, Olympia, and several other Washington cities have also enacted their own local tenant protection ordinances that add requirements beyond state law. For fixed-term leases, The lease expires at the end of the term, but under the new just cause framework, the landlord must offer the tenant a renewal on similar terms unless they have a qualifying reason not to. Simply allowing the lease to expire and asking the tenant to leave without cause is no longer permitted. On the tenant side, Washington provides several grounds for early termination. Tenants who are victims of domestic violence, sexual assault, or stalking can terminate early by providing written notice and documentation. The tenant must give at least 14 days' notice, and the landlord cannot charge an early termination fee or report the early termination as negative rental history. Tenants can also terminate if the landlord fails to maintain habitable conditions. As we covered in our Washington habitability video, the state has aggressive repair timelines and tenant remedies that include lease termination when essential services aren't provided. Active duty military members are covered by the Service Members Civil Relief Act, with the standard 30-day notice following deployment or permanent change of station. Washington also provides early termination rights for tenants who are at least 60 years old and need to move into a care facility, as well as tenants whose rental unit has been designated as uninhabitable by a government agency. Washington strictly prohibits self-help evictions. Landlords cannot change locks, shut off utilities, remove belongings, or take any action to force a tenant out. Violations can result in the tenant recovering actual damages or up to $100 per day for each day the violation continues, plus attorney's fees. These penalties add up quickly, making illegal lockouts extremely costly. The eviction process in Washington goes through Superior Court and requires strict compliance with procedural requirements. Any defect in the notice, wrong dates, missing information, improper service, can result in the case being dismissed, forcing the landlord to start over. Given the complexity of the current framework, having experienced legal counsel handle eviction filings is strongly recommended. For the complete guide to Washington's lease termination laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our series.